Yes, good afternoon, everyone. Am I audible?
Yes, you are audible.
Yes. I'm Adaisha Hota, and I've been joined by Ritik Khatri, and we would be representing NLO here. So, the grand vision for a litigant-centric judiciary has various subcomponents to it. For instance, unlike popular perception, a litigant is interested not just in quick resolution of disputes, although that is one of the key expectations from judiciary. They are equally interested in the overall transparency of the system, accountability of judges, efficiency of processes, and as an end result, yes, a just outcome. This indicates that the journey towards transforming Indian judiciary from a colonial relic to being litigant centric should be guided by an array of base level changes. It could be as basic as explaining court processes and decisions. A series of guides could be produced with answers to frequently asked questions, as well as information leaflet that tells them what happens during a court proceedings in both civil and criminal cases. Additionally, with a shift towards digitization and the ad hoc introduction of technological interventions, the current system and processes have become even more complex and layered. Therefore, increasing legal digital literacy among all the stakeholders is extremely necessary. As we all see, the rights of the press and other media to access information as a cornerstone of our countries as well as the judiciary's democratic accountability. One aspect of better communication is the court's relationship with the media, as it is the conduit for connecting with people. It can be a potent tool to bridge the gap between litigants and judiciary. Secondly, we would emphasizing we would emphasize on ensuring access to case laws. One of the first steps that should be provided is ready access to laws, procedures, forms, and documents. At present, there are numerous research databases for the same, but some of them do not house enough data, and the ones which do charge a hefty fees to access the same, and none of these are layman friendly. The judiciary should have websites as reference points with national legal texts, case laws of higher court as well as lower courts, and enable users to download forms free of any charge. A step in this direction has been taken through the e-court project, but as it is only led by the Supreme Court, it fails to account for the peculiar difficulties that the respective High Court and District Courts faced in actualizing this into a reality. The next point we wanted to raise has already been discussed by our previous discussants on how law students can be of help. So I would not dwell on it anymore, but I would encourage to use law students as a tool through internship, legal aid, etc., as they come in contact and in aid of all three, the judiciary, the lawyers, as well as the litigants or common public. It will also help in acquainting the next generation of lawyers and judges to courts' functioning and procedures. Moving on, many of the issues that the judiciary faces are inherently structural. For instance, a persistent problem faced by the judiciary has been the lack of coordination between all its tiers, often resulting in some states or districts being blindsided during the decision making process. Thus, there's a dire need for structural mechanism that can bridge this information asymmetry between the tiers of the judiciary. It would allow for representation, grievance redressal, and encourage exchange of information. While there has been a conscious shift over the years to engage with external stakeholders and the general public in policy making, no mechanism or practices seem to be baked into the judiciary's functioning. While it is now taken for granted that the government will put up bills and most policies for public consultation, the same does not hold true for judiciary. Rules of practice and procedure followed by the court should ideally receive and be amended in line with real-time input sourced from the experience of
Sorry to
courts.
interrupt. Kindly wind up your points.
Yes, ma'am. So this point was basically that the rules of different courts with respect to documents required to enable court procedure, grievance redressal, gaining information about the procedures, etc., should be streamlined and till the extent possible uniform for all the courts. Presently, civic society struggles to find accessible entry points to engage with the judicial system, given the opacity with respect to its policies and rules, even in areas that impact litigants or the general public directly. The need for the future, according to us, is to ensure this entry point, and it can be started by providing ease of access to court procedures and information to stakeholders. To sum up, the vision for the future is a litigant friendly justice system where they are empowered with all the information they need and do not have to run from pillar to post to access justice. Thank you.